Anything under the sun that is made by man is patentable. So said Justice Burger in the 1980 Supreme Court case, Diamond v. Chakrabarty. In this video, I want to take a look at some examples of things that are not patentable. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. So laws of nature are not patentable. The speed of light is not patentable. E equals mc squared would not be a patentable formula. Likewise, natural phenomena are not patentable. The freezing of water into ice is not patentable, nor is the fact that ice floats, which, by the way, is probably only second to gravity in terms of importance as natural phenomena go. If ice didn't float, there'd be no life on Earth. Also, by the way, gravity is not patentable. Molecules and organisms that are naturally found, that are found in nature, are not patentable. However, the process for making a molecule or for building an organism would be patentable. Mathematical formulas are not patentable. For example, the multiplication table would not be patentable, but a method or a process for accelerating high-speed multiplication in a microprocessor could be patentable. Likewise, formulas such as the Fourier transform, which is fundamental in music processing and digital image processing of video. However, the decades-old Tukey-Cooley algorithm of fast Fourier transform that is used today in digital signal processing would have been patentable had the inventors thought to patent it. Abstract ideas are not patentable. For example, the idea of buying high and selling low is not patentable, although there have been inventors who've tried to patent it. Other examples of abstract ideas might include organizing a phone directory alphabetically. This would not be patentable because it's an abstract idea. Inventions that don't work are not patentable. For example, a perpetual motion machine would not be patentable unless someone could actually prove that they're getting work out of the perpetual motion machine. Anti-gravity machines or time machines would not be patentable unless their utility could be proved. Articles contrary to the public good are not patentable. Now, this is fairly curious because it's a bit political, as the norms for what is good for the public tend to change over time. For example, 20 or 30 years ago, a roach clip or a device for holding the butt end of a marijuana cigarette may not have been patentable, whereas today the utility might be a bit more acceptable, especially if it was characterized as jewelry, for example. And a final example of inventions that can't be patented are national secrets. For example, materials for atomic weapons are not patentable, presumably because we don't want to teach the world how to make nuclear weapon material. And there are some inventions that are submitted to the patent office where the patent office does not permit patenting because of reasons of national secrecy. And this occurred for me some years back. Around 30 years back, I submitted 4 or 5 patent applications relating to cold fusion. There was a lot of interest in this in the early 1990s, and various entities and research organizations submitted patent applications related to cold fusion. Now, the applications that I submitted were immediately covered under a secrecy order. Now, I'm not exactly sure what happened to those cold fusion applications, as my client lost interest in pursuing this research area. It turns out that for the most part, cold fusion, at least in the early 1990s, was considered to be theoretical and probably not functional using the techniques that were available at the time. Okay, those are my examples today of things that cannot be patented. If you have some other ideas or examples, please put them in the comments section below. We'd love to read about them. Thank you so much for watching my video, for staying to the end, for liking and subscribing. I'll see you next time.